everyone. It's Brad Chaplik. I am hosting our weekly AMA Ask Us Anything, or Ask Me Anything, I guess, if it's AMA. As usual, the format is to type your questions into the Q&A, and I will answer your questions to the best of my abilities. Starting off, I know some people are still connecting to the meeting, but so I'll give it a quick moment for everyone to get connected. And then we'll talk about what's going on in condo land. A couple of things going on, nothing too crazy though. So first thing that's going on in condo land is an announcement that came in just today from the Condominium Authority that electronic meeting provisions have been extended to September 30th, 2022? I think so. Let's double check. Got the release right here. Yeah, September 30th, 2022. So these were the restrictions that were set to expire on December 31st. And so just to clarify, the restrictions that we're talking about, I'm going to read off my other screen here. So first is the calling meetings of the board. So and the ability to hold board meetings by teleconference without the requirement for consent of all directors. So the normal law under the Condo Act is to say that you need the unanimous consent of every single director to have a board meeting by teleconference. That law is temporarily suspended, and it allows the meetings to be held by teleconference even if a director objects. That law was supposed to expire December 31st, 2021. It's being extended to September 30th, 2022 for reasons that are obvious. Okay, so that's part number one. Part number two is, okay, what's the next one here? Oh, how to give notice of a board meeting. So like you can basically give the notice electronically. Okay, easy enough. Section 5. The next one is, how to determine quorum for an electronic meeting. So basically allowing people to connect to meetings electronically and be counted for quorum purposes. And the next one is allowing electronic voting. And then the last one is allowing service of a notice of meeting electronically, even if the owner hasn't completed a consent to receive electronic communications. So basically, altogether, these are the provisions pertaining to electronic board meetings and electronic AGMs or other meetings of owners. And they were all set to expire December 31st, 2021, and they've all been extended to September 30th, 2022. So if you were a condominium corporation who was thinking about passing an electronic meetings bylaw, which is a low threshold bylaw, and you haven't done it yet, and you were worried about the December 31st, 2021 deadline, the Ontario government has bailed you out, and you now have until September 30th, 2022 to continue holding meetings electronically without a bylaw, after which time you will need a bylaw if you want to continue to hold electronic meetings after September 30, 2022. So I think that's good news for most condominiums. It was widely expected that it would be extended, and because it was originally extended to December 31st. It was supposed to expire earlier, and then, excuse me, after that, we thought, oh, this isn't going to end. It needs to be extended again. So it was. So let's get to some of the questions. We've got 2 questions in our queue. So the first question comes from Catherine, and she asks, excuse me, are board members permitted to see security reports, review video surveillance footage, suite information, names of occupants, owner or tenant telephone numbers, email addresses? Are board members permitted to see these things? Okay, so there is a short answer to this question, Catherine. The short answer to the question is yes, with the permission of the board. So a decision as to who can see a security report is a board decision. So if an individual director wants to see a security report, then it would be a board decision to allow the individual directors or that individual director to see that report. So if a director comes up to you, the condominium manager, outside of a board meeting and says, please show me the security report, you would say to that director, outside of a board meeting, you're not acting in the capacity as a director unless you've been given that authority by the rest of the board. So that's very difficult for condominium managers to say to the directors. So let us say it, just flip that question to the lawyer. Hopefully you have a lawyer who's not going to charge you to give you that answer. And then the answer is that the privilege to do this has to be given by the board to the individual director, and then they can. And I think that resolves your question, Catherine. But there's a hidden issue in that question, which is the fact that you should have a privacy policy. And if you have a privacy policy for your condominium corporation, then the privacy policy already deals with this issue, because privacy policies say, for example, on especially for security cameras, surveillance footage, which is part of your question, they say who can access that footage and only authorized persons, and who are those authorized persons, and it's authorized by the board. And so in the case of most condominium corporations, a person authorized to review the security footage is the property manager and the security team. And the board members are not authorized unless that authority is specifically given to them. So that's the longer question and the bigger issue, which is, this is why condos need privacy policies. But as for the individual unit owner records, the board does have the right to examine those records. It's a board decision, not an individual director decision. Outside of board meetings, individual directors are just owners. So that's Catherine's question. It's a great question. It's come up before. It's a good one. Thank you again, Catherine, for bringing that to all of our attention. Next question comes from Paul. Paul asks, what is your opinion of having the property manager chair the annual general meeting in light of the property manager's code of ethics under licensing, which clearly states avoiding any conflict of interest, remaining neutral, which when chairing meeting could be easily perceived there's a conflict, especially concerning elections, seems to be mixed opinion on this. Okay, Paul, what's my opinion on property managers chairing meetings? I think chairing meetings is actually a very difficult thing to do well. Some licensed condominium managers are excellent at it, and some are not. So if you have the skill and capability to effectively chair a meeting, I don't have a problem with it. When you are a chairperson, you are acting in a neutral role, right? You are operating like a semi-judicial function. So as a condominium manager, it's perilous because you may feel that you have an obligation to take instructions from the board. But when you are the chairperson, you do not take instructions from the board. You have to make decisions. And if you feel as a condominium manager that you cannot easily make decisions that might run contrary to the board because you're worried that your decisions will, affect your job security or whatever, then you're not arbitrary, then you're not neutral. And then you can't be the chairperson, and you shouldn't. And you should say, you know what, I can't really do that because the president's going to be sitting right next to me and she's going to ask me to not let someone talk. And as the chairperson, I can't do that. I have to be neutral. And so I think it might be your preference as a condominium manager to say, I don't want to put myself in that position. Let the lawyer do it, or let the regional do it, or let the president do it. All of those are options as opposed to the site manager. Most condos bylaws say that the president chairs the meetings. So, but again, chairing meetings is actually quite difficult to do well. A lot of people can do it, but to do it well, you do need a lot of experience. And in a perfect world, your meeting would be chaired by an experienced lawyer, someone who does them all the time. And, I've been chairing condo meetings for 12 years and I've done many, many hundreds of them. And that experience is helpful because issues reoccur and I can learn from past mistakes. So those are my thoughts, Paul, and be interested to know what you think. All right. Naz asks, hi there, following your explanation on showing a security report to a director, what if they ask to just see it, read it in my presence? Also, what if they ask to look at the footage of something, not to be given the footage, just to be shown the footage? Same answer, Naz, same answer. Like I said, as outside of the board meeting, the director is just an owner. And it would be no different than any other owner asking you to just see the report. Security reports are records of the corporation. They're producible under certain circumstances upon request by a unit owner. Usually it's because the report pertains to the individual owner, but they also have private information in them. And I would say to a director asking to see reports and things of that nature, let's pass a board resolution authorizing all the directors to see all this type of records all the time. And then once it's authorized by like a general board resolution, giving the board members that authority to go and see records whenever they want, then it's not your call as the manager, it's the board's call. So same answer, but good question. Yeah, there's some nuance to it. All right. Nithika, condo manager, asks, we recently had an AGM and the standard unit bylaw and insurance deductible bylaw was not passed. So we adjourned the meeting, hoping to provide a better understanding of the bylaws and to have a meeting soon on a snapshot. Was it the benefits of having both bylaws for the owners? How can we explain in layman's terms? Oh, I want to understand your question better. Okay. Oh, how can you explain the bylaws in layman's terms? If that's what you're asking me, I can give you some help about that. So I'll briefly explain it now, but the basic answer, I want to briefly explain, okay, insurance deductible bylaws are important because they allow the condominium corporation to recover the deductible portion of the insurable loss, the portion that is not covered by insurance that would otherwise be paid by the unit owner, from the person who caused the damage. That's it. That's all. To explain, what is an insurance deductible bylaw? It is a bylaw that allows the condo to recover the portion of the loss that is not covered by insurance from the person who caused the damage to the building. And if you, as a unit owner, are worried because maybe your condo has a very large deductible, it could be like $50,000 sometimes, or more realistically, like 25 or 10. But if $25,000 for an insurance deductible is a lot of money, as a unit owner, you can purchase coverage as you're under your homeowner's insurance policy for corporation's deductible. And then it's just shifting the responsibility for the deductible from all of the innocent unit owners onto your homeowner's insurance. So that's how I would explain insurance deductible bylaw to a lay person. And that you might need to explain what an insurance deductible is to someone, but that's not a legal issue, that's an insurance issue. And then a standard unit bylaw, the best way to explain a standard unit bylaw is to say, when there is damage, insurable damage to a condominium unit, there is a part of the repair is the condominium insurer's responsibility, and part of the repair is the unit owner's responsibility. And the standard unit bylaw basically says what goes under the condo's insurance and what goes under the unit owner's insurance. Basically, everything that is part of a standard unit is the condo's insurance, and anything else is deemed to be an improvement and goes under the unit owner's insurance, even if it was original. So for example, you could deem all floors to be improvements. And then the purpose of having that bylaw is so that the insurance companies don't fight over what is standard and what is not. Most new condos already have a standard unit schedule and they don't need a bylaw. The standard unit bylaws are mostly for older condos or for condos that have had a large number of insurance claims and need to reduce what's covered to bring their insurance premiums down to a reasonable level. So that's how I would explain it. If it were me, that's what I would say. All right, Paulette. Paulette asks, with board meetings being recorded, are they considered records of the corporation if an owner is requesting to see it? There are minutes of the meeting, and once they approve, they are posted. However, a couple of owners are wanting to see the recordings, citing that too as a record of the corporation. Very interesting question, Paulette, comes up quite a bit. I would want to check like the latest CAT cases to see what CAT has said about this. But in the older, not older, like a year old, the last time I looked at this issue at CAT, which was not this year. I haven't looked at it this year, but I looked at it in 2020 and 2019. The leading thought was that a recording of a board meeting is not a record of the corporation. It is a work product of the minute taker. So the minute taker, the record of the meeting is the minutes. That's the record. The recording is used to create the minutes. And so what I would say you should be doing is, once you approve the minutes of the board meeting, delete the recording. Once you delete the recording, then there is nothing to provide. So that's, if you're going to record your board meetings for the purpose of having accurate minutes, after you approve the minutes, you can't change them after that. So there's no lingering reason to have a recording of that board meeting. It should be deleted. Because if the recordings are records of the corporation, there is an obligation under the Condominium Act to keep these records for 6 years at least. And if it's a true minutes of a board meeting, they have to be kept forever. And so if it were true that these recordings were records of the corporation, you would not be able to delete them. And to my mind, that can't be true, right? Of course, a person who takes a recording like the minute taker would be able to delete that once it's no longer needed. So I would say the person who has the recording ideally should be the minute taker. If the minute taker is not a director, then you would say we don't have the recording. The recording is with the minute taker, and the minute taker deletes them as soon as he or she is done making the minutes. So I would say it's my best understanding, Paulette, is that they are not a record of the corporation, but CAT makes all kinds of rulings on these things, and their decisions are coming out all the time. So I would have to really check to double check that that's still the prevailing view at CAT. But last time I checked, not a record. Okay, condo manager asks, you indicated that outside of a board meeting, the director is treated as a unit owner. What is the reference on that? Oh, so like, what's the statutory authority for that? Sure, I will tell you. I believe it's like 32 or something like that. Conduct of business, section 32. The board of a corporation shall not transact any business of the corporation except at a meeting of directors at which a quorum is present. So that's 32 sub 1 of the Condominium Act, and that clause in plain English means that board members can only perform their function as board members in a board meeting at which a quorum of the board is present. If the board meeting loses quorum, they can no longer perform any business, and an individual director really can't act on behalf of the corporation outside of a board meeting unless they were given that authority in a board meeting. And there's lots of case law about that, but that's the statutory authority, section 32 sub 1 of the Condominium Act. I'm sure you're asking me so that you can tell the director when they ask you. So great question. Sabrina asks, what section of the Condo Act applies to the requirement of WSIB certificate and liability insurance certificate from vendors? Oh, it's not in the Condo Act, Sabrina. It's just a requirement under occupational health and safety law that you would, when you have people starting work, like major contracts, that they need to show you what's called a clearance certificate from WSIB, and that they have proper liability insurance. So it's just something that the condos do to protect themselves. It's not in the Condo Act. It's not like a legal requirement in the Condo Act that you can only use contractors who are giving you proper insurance certificates. It's a standard due diligence practice by basically all condominium corporations that you would require these things for any major project. And it may be required, like I said, by the Ministry of Labor and those kinds of things, but it's not part of the Condo Act. Paul says, okay, so Paul's back. Understanding what you said, my question is it worth the potential liability to the property manager in hosting the AGM? So we're back to should the condo manager host the AGM question, which I really like this question. Assuming that they have the knowledge and experience, the CMRAO will not state that we are exempt from liability under ethics doing this role. No one wants to deal with a CMRAO complaint. Hey, Paul, I get you, man. Like, that is part of my answer, right? You are bound by your obligations as a licensed condominium manager in all of your functionings for the condo. But as a chairperson of a meeting, you also have the same as the chairperson of the meeting, you also have the same obligation to be neutral, right? So it's not just in your capacity as a condominium manager that you have the obligation to be ethical and fair. As a chairperson of a condominium meeting, you have a separate legal obligation to be a proper chairperson and to be neutral and independent and fair. And there are, as you know, I'm sure, Paul, there are specific rules about collecting proxies that say that the condominium manager cannot solicit proxies for voting for the election of directors. You can only solicit a proxy for basically quorum purposes. And so knowing that, you may want to sort of recuse yourself from the role of chairing the AGM and say, look, it's not worth it. I don't want the liability, but I don't want a CMRAO complaint. But to me, the issue is not the CMRAO complaint. The issue is that there's just inherent liability chairing meetings that you don't want. The CMRAO is just an example of how it's become easier for unit owners to make complaints over perceived wrongdoing by condominium managers. But the risk was always there that you would, as a chairperson, make a mistake or not act fairly and be determined to have done something wrong. So I guess my answer is the bylaws say that the president of the board should chair the meeting almost all the time. And if the president doesn't want to do it, the next best person to do it is the condominium corporation's lawyer. And if you don't want to pay for the lawyer to do it, I would try to get someone from the management company who is like an executive of the management company and who's not the site manager for that specific site. That would be sort of the arm's length kind of approach that you'd be looking for. And then that person can chair the meeting in a more neutral way and not in the way that a condominium site manager chairs it, where they might feel that they are under like duress or something from the board to conduct the meeting in a way that the board wants, but may not be the best way to do the meeting. I think that's what you're getting at. Okay, more questions about recording minutes. Apparently this is a hot topic. Not surprised, it comes up all the time at CAT. Elaine asks, how do we email the transcript to ourselves? Are you talking about of this Zoom webinar? Like you want to email this transcript? I'm not sure that you can. It's closed caption, but I don't know if it produces a transcript. If you're talking about like your board meetings, then I don't know, but that's a good question, Elaine. Technically, how do you email the transcript of this seminar to yourself? I have no idea. Justina, does this also apply to AGM recorded minutes too? Okay, so this is about the board minutes. And now she's saying, okay, well, we record our AGMs. Elaine saying, yes, this webinar. Elaine, I wish I knew how to email the transcript of this webinar. I do not know if it is possible. And if it is possible, I do not know how to do it. I just answered the questions. I'm so sorry. Okay, Justina asks, does this also apply to AGM minutes? Yes, everything that I've said about board minutes would apply equally to a recording of an AGM. The goal would be that the recording of the AGM would be kept by the minute taker, just for the minute taker's own purpose of producing the AGM minutes. And then the difference is that your AGM minutes don't get approved by the unit owners until the next AGM. So you're holding on to that recording for a year, and then you're going to delete them afterwards. Whereas in comparison to a board meeting, you can approve the board minutes at the next monthly meeting. So you're holding on to that recording for a much shorter period of time. And therefore the chance that you're going to be asked in a request for records to produce it is less. But yeah, the principle is the same, Justina, for board minutes and AGM minutes. You just hold on to the recording until the minutes are approved, and then there's no longer any need for the recording. Leo asks, would an AGM video recording be treated as a work product of the recording secretary and not as a record of the corporation? Yeah, that's my position, Leo. You got it. That's exactly what I would say. And there's authority for that. And the authority for that is a case called Stewart, Ian Stewart versus TSCC 1591. It predates all of the recent CAT stuff. It's an old case from 2011. And the lawyer for the Condominium Corporation who successfully argued this exact issue had to do with minute takers and handwritten notes, not a recording, because it was a long time ago. And so the small claims court held that this was the work product of the board. It was not a record of the corporation. It did not have to be produced. And the lawyer for the condo was a guy named Brad Chaplik. So that's how I know about that case. And that case was appealed to divisional court, and I won the appeal. So there you go. So that's how I know so much about that. I had to deal with it. Irene asks, can a board member take a leave of absence from a board? And what if a board member does not accept, what if board does not accept reasons for not participating as a board member? Oh, can you take a leave of absence? Okay, and then let's get to the second question, and then I'll answer the first one. If a board member has requested records, is it true that CAT considers this a conflict of interest and the member should not continue serving on the board? Okay, all right, Irene, let's talk about this stuff. Can a board member take a leave of absence? I don't see why not. The only reason why this would not be permissible is if your bylaws said that directors who do not attend board meetings are not eligible to continue as directors. So some condos have enhanced eligibility criteria for directors and disqualification criteria. And they say that if you miss like 3 board meetings in a year, you're disqualified from the board. If that is not in your bylaws, then there's nothing to stop a director from simply saying, I'm not coming to board meetings. But they're not, there's nothing formal to say that they've taken a leave of absence. They still have all of the liability of a director, as if they were participating fully. Like just the fact that they're saying like, I have a physical illness, or I have to take care of a family member, I'm not available for 6 months, right? And they say, I'm not resigning, but I'm not available. You should still copy them on emails, and you would give them notice of all the board meetings, and they just can choose not to reply, not to vote, to abstain on every single vote. And so in a sense, they've taken leave of absence, but technically you've done nothing, and they would remain a director. Now, if a director feels that they cannot continue as a board member, they should really just resign, because it's not fair to the other directors who are left with the extra burden of work that, having to take on all this stuff. So, okay, question number 2. If a board member has requested records, is it true that CAT considers this a conflict of interest and member should not continue serving on the board? I don't think that's true. I don't think that's true at all. You can be a condominium director and have a legal dispute with the condominium corporation. And yes, you are in a conflict on that dispute, but it doesn't mean that you can't be a director for other purposes. Happens all the time, because directors are unit owners, and unit owners have disputes with condominium corporations. And so if you were a director and you were requesting a record and the dispute went to CAT, you could not participate as a condominium director in that CAT case, or, and you'd have to recuse yourself from all discussion, legal advice that the corporation receives, because you're opposed to the condominium corporation in interest, right? This is when people say conflict of interest, what are we talking about? Here's what we're talking about. You have an interest as a director, which is you want the record. The condominium corporation has an interest in which they do not want to provide you the record. You are opposed in interest. You have a conflict of interest, but only on that issue. You don't have a conflict of interest on everything that prevents you from being a director. So I hope that answers your question. What does a conflict of interest mean? It is a term that is frequently used and poorly understood. Not saying that you don't understand it. I'm saying generally, it is poorly understood what is meant by the term conflict of interest, because we don't understand what is meant by interests. We mean legal interests, not like preferences. PCC, condo manager asks, the manager receives a decision from the president of the board, speaking on behalf of the majority of the board, indicating that the only person authorized to liaise with management will be the president. However, one board member does not respect this decision. How is the manager supposed to act in this situation? Very good question. The manager must take instructions from the board. If the board has voted, that the liaison will be the president, which is frequently the case, then the condominium manager must take that instruction and follow it. And the dissenting board member also has an ethical obligation, once a vote is held, not to undermine a board's decision. So up until the moment when a board makes a decision, board members can and should have personal views on the matter. Once the board votes and a decision is made that the liaison is going to be the president, all directors have an ethical obligation not to undermine the board's decision by actively taking steps to, try to subvert it or do these kinds of things. And there's a case about that called Ballingall from Ottawa, which says that a director who attempts to subvert and undermine a board decision after it has been voted on is acting contrary to the director's duty of care under Section 37 of the Condominium Act. So the director who does not respect the decision and is trying to undermine it is acting contrary to that director's legal obligations, and the property manager should respect the board's majority decision. Excellent question, Ballingall. Very important case out of Ottawa. Hugely important case about when is a director breaching the director's duty of care. Paulette asks, Stewart v. TSCC 1591-1591. Is that the correct condo number? Yes, it is, Paulette. Case is available on Westlaw. Any lawyer can grab the case for you. Paul asks, new topic. Great. Generally, we have believed that minutes should be resolutions and motions. Very little other detail, as conversations have caused trouble in the past. Now there seems to be a decision that states that minutes didn't contain enough info. How detailed should minutes be? Should an AGM minutes contain the Q&A, questions and answers, and other discussions that occur from the owners? Okay, so this question is about annual general meeting minutes. Okay, so Paul, it is the minutes of your annual general meeting is not just a list of the motions. It is more than that. The minutes of the meeting does or should include all of the business of the meeting. And the business of the meeting does include Q&A to the auditor and the other business. And it may also include things like objections and points of order. You can also attach schedules to the minutes. For example, if the president gives a report and the report is in writing, you can attach the president's report as a schedule to the minutes. So to answer your question, Paul, the minutes should include more than just a list of the resolutions, but they are not a transcript of every word spoken at the meeting. So if someone gives a lengthy answer to a question, the minutes can compress that answer down to its key points. And need not be a word for word transcript. So I think that answers your question. There should be some Q&A and specifically, what is the question from the owner? What was the answer that's given? That should appear in the minutes. That is the standard practice for condominium corporations. Oh, and Paul's saying, I was talking about both board meetings and AGM meetings. Okay, recognizing that there is a difference. Yes, so there is a difference because the AGM actively has like Q&A as part of the business of the meeting, and that's required by the Condominium Act. So this is another important point, which is why do I say that the Q&A is part of the business of the meeting and therefore needs to be included in the minutes? Well, because the Condo Act says that owners have the right to ask questions of the auditor, and it also says, like, why do we have other business in AGMs? So this is a really helpful point. Section 45 sub 3 of the Condominium Act 1998 says, at an annual general meeting, an owner may raise for discussion any matter relevant to the affairs and business of the corporation. So that means that it is properly before the annual general meeting for an owner to raise for discussion any matter relevant to the affairs and business of the corporation. And if the Condominium Act says that owners have that right, which we generally call other business, then of course the other business section of the meeting should be included in the minutes. Now, the same is not true of board minutes. For board minutes, you're going to look at your bylaws because your bylaws might specify what information has to go into the minutes. And I would say that in board minutes, there should be context for the votes. So it's not necessarily like Director A said this, Director B said this, but it's like, what was the subject matter of the thing? So it's not just, therefore be it resolved, a quote for landscaping, it was approved in the amount of X dollars. It should be like, the board received 3 quotes for landscaping from companies A, B, and C. Company A was the least cost. Therefore, on a motion by so-and-so, seconded by so-and-so, the lowest cost quote was approved by the board. So in this case, you're giving context and like the reason for the decision without the verbatim, like what did each director say? So it's not really important what each director said in the board minutes, but rather like what was the reason for the decision or how did the board reach the decision? You want to have some context for the resolution. So I hope that helps. Yeah, you don't, it's not a transcript, but it's not just motions. There has to be context. An owner reading the minutes has to understand what the board is doing. Catherine, a locker gets broken into and the hook/loop where the lock goes in was damaged. Is the owner responsible for the repair or is the corporation responsible for the repair? Interesting. Okay. So I believe vandalism or like theft might be insurable losses where the condominium corporation might end up being responsible for the repair unless you had a standard unit bylaw that said that basically in a locker, everything is considered an improvement and the owner is responsible. So this could be like a standard unit bylaw question as to who is responsible for the repair because of like crime is considered an insurable loss, which the corporation would otherwise insure. Otherwise, it might be the condo who's responsible if you don't have an insurance deductible bylaw. You'd also want to check your declaration and the like boundary of the unit to make sure that the actual like the hook locking mechanism is not common element. Because of course, if it's common element, then the condo is going to be responsible. So it's going to check, yeah, so you're going to check your boundary of your locker unit or if it's common element, and you're going to check if it is relevant to your standard unit bylaw. But it's not an obvious question, Catherine. It's going to depend, it's going to be different from condo to condo. Good question. I'd have to check. I'd have to look at your condo docs and see. Leo asks, let's see. Okay. Leo asks, a board member's sister works for condo control and the corporation uses condo control. The board member declares that her sister works for condo control and abstains for voting on issues discussed about condo control. Is this sufficient to protect the board member? Yeah, so it is sufficient. So let's review what the Condo Act says about this. It's section 40. So we go to section 40 of the Condominium Act. Disclosure by director of interest. So a director who has directly or indirectly an interest in a contract or transaction shall disclose in writing to the corporation the nature and extent of the interest. And then the timing of the disclosure, it says that it must be done at the meeting of the board in which the contract or transaction is first considered. The board shall enter the disclosure made by the director into the minutes of the meeting at which the disclosure was made. The director cannot vote and the director cannot participate in any discussion. So the director actually has to be like physically leave the room when the issue is being discussed. It's not just enough to declare and abstain from voting. You actually not be present while it's being debated by the other directors. So you're almost there, Leo. There's one more step in the abstaining from voting, which is to also abstain from discussion. And all of that has to be recorded in the minutes as having been disclosed. If you do that, then you've satisfied section 40 of the Condominium Act, and the director has met all of his or her legal obligations. Condo bylaws might have additional obligations in them. That would be it. Oh, the director might also have to disclose it under the director disclosure requirements in the Condominium Act. So there's also an obligation for all directors and all candidates to disclose if they have an interest in any contract or transaction to which the corporation is a party. So that disclosure also has to be made to the corporation. I think you've probably satisfied it by just advising the corporation of the fact. But if the person's running for election to the board on their little candidate disclosure form, they would probably want to disclose it there, even though perhaps in this case it would not be considered a material interest, just that your sister works for condo control. I mean, the more relevant interest is if you're like your sister owned condo control and was therefore in a position to like benefit from the profits of the company. I don't think just being an employee is necessarily sufficient to be a material interest, but better safe than sorry. Okay, I answered all your questions. We've been going for 40 minutes. It's not too bad. I'll talk about a case, and if any questions pop into the Q&A while I'm talking about the case, I'll answer those questions, and then we'll call it a day. So the case I'm going to talk about is from the Condo Tribunal. It was released on August 25th, 2021. So it's pretty recent still. It's only about 6 weeks old. And the case is Essex Condominium Corporation 25 v. Ferrari, like the motor vehicle, 2021 on Cat 79. Essex 25 and Ferrari. And this case, ironically, is about parking. So it's about parking a vehicle. And what happened in the Ferrari case is they were not parking Ferraris, they were parking pickup trucks. The condominium corporation had a underground garage, and the pickup trucks did not fit in the garage. And for many, many years, the owners of the pickup trucks were, I don't know if they were permitted, but they parked in visitor parking, which was above ground. And the condominium corporation determined that this was not permitted. Of course, it's not permitted for the residents of the building to park in visitor parking. And they gave them a significant amount of time, I think it was maybe like a year, to find alternative parking. So, so that's what happened. So the condominium corporation gave notice to all the residents who are parking in visitor parking and says, look, you can't continue to do this. You have like a year to find alternative parking. And if you don't, we're going to require you to stop parking there. And they didn't stop, and they said, no, we parked here for 20 years and we like just bought a new pickup truck that doesn't fit in the garage because we knew we were allowed to continue parking visitor parking. And had we known, we wouldn't have bought a truck and we would have bought a different car, and you can't make us do this and it's unfair and blah, blah. So what does the Condo Tribunal say? Condo Tribunal says something very important, which is that it is permissible for a condominium corporation to, quote, stiffen up the enforcement of your rules. Even though the rule about parking and visitor parking was not enforced for like 15 years, the new manager comes in and says, I have a mandate with a new board and a new manager to enforce this rule, and you cannot continue to park in visitor parking. And that is permitted as long as you give people notice, which is what they did, that the rule was enforceable. It was reasonable on its face. The fact that the people had purchased like I think a Ford F-150 pickup truck, which was too large for the underground garage, was not the problem of the condominium corporation. It was not specific to like all pickup trucks. A smaller pickup truck would have fit in the garage. They just had a particularly large one. And the rule was enforced, and the unit owners were required to stop parking in visitor parking. I think they were given like a period of time to comply, after which they could be like ticketed and towed. And so it seems like a simple enough case, but it's important because it has a broader context for condominium corporations pertaining to stiffening up the rules enforcement. And in particular, that you want to give notice when you're going to do that. So what would not have been fine would have just been to like, they've been parking there for 15 years and out of nowhere you start towing them with no notice. That's not okay. And I think all of you inherently understand why that would be. So if you're going to start stiffening up the enforcement, give notice. And you would want to give notice to people anyways, right? Anytime you're enforcing rules, you're going to start with a warning. And that's the way to do it. And the Condo Tribunal says that's how you should do it. And I agree. I think it's a good decision, and it's one that you should keep in your back pocket if you ever find yourself in the situation of, walking into a new community and being asked to change the way things have been done in the past. And you get some pushback from owners, inevitably, who say, well, it's always been done this way in the past. You can't change it now. And the answer is yes, you can. You just have to give notice and be fair to people. So 12:45. Thanks, everyone. Amazing questions today, as always. And we got to talk about the extension of electronic meetings to September 30th, 2022, announced just this morning, so hot off the presses. And we talked about the Ferrari case, which sadly did not involve any Ferraris other than the people. The cars were F-150 pickup trucks parked in visitor parking. All right. Thanks, everyone. That's all for today. We'll see you again, I think most likely in like 2 weeks. We think we've been doing this every 2 weeks. So Wednesday at noon, and it'll probably be Brian Horlick or maybe, Brian and guest. But we really love doing these AMAs for you. We'll keep doing them as long as you guys keep watching them. And see you in a couple weeks. Stay tuned, email list whenever anything changes with COVID regulations or anything else. We send out the email blast letting you know what's going on. We'll keep doing that. And so far, so good. Things have been kept the same for more or less the past month. All right, everyone. See you again soon. Bye for now.